Good evening. As Jakari said, my name is Ronald Languidoc. I'm a tenant attorney with the firm Himmelstein, McConnell, Gribben, and Joseph. I've been there since 2008. Before that, I was a legal aid attorney or legal services attorney for 25 years representing tenants. So I have a total history of um, over 40 years representing tenants. Um, I was asked to speak to you about what is a Frankenstein apartment and how does it affect rent regulated units. And I was asked to speak for about 20 minutes and then open the floor to questions. A little bit of history into the issue. The history goes into kind of two different directions. So the first is loopholes in rent stabilization, which there used to be many. As you know, a lot of you probably know, rent stabilization started in 1969. As the years went by, various loopholes were put into place whereby landlords were permitted to jack up rents dramatically or even deregulate apartments. So one of those was what used to be called first rent or first rent doctrine. And it went like this, more or less. You have an apartment that's rent stabilized that has a particular rent, particular legal rent, and it becomes vacant. And say the apartment next door to it, adjacent to it, also becomes vacant. So the landlord combines the two apartments and makes one large apartment. Or there are other variations, which we'll get to. But under the first rent doctrine, which is no longer the law, but it was for many years, the landlord would be free to charge whatever rent they wanted, the market rent, for that large combined newly created apartment. So that the rule as it gradually came to be recognized was that if a landlord enlarged the outer dimensions of a rent stabilized apartment, such as combining two apartments, combining one apartment with half of another apartment, combining an apartment with a part of the public hall, or combining, or even taking an apartment and making it into two apartments. The prior rental history would be irrelevant and the landlord could charge a market rent. And then the doctrine developed further to the point where the owners could deregulate the units completely so they wouldn't be under rent stabilization. So this loophole existed for many years, and it was a reason why people would notice in their apartment buildings that an apartment became vacant. A landlord would often not re-rent it, rent stabilized apartment. They would wait to see if the adjacent apartment could become vacant, or if they could harass the person into leaving, or somehow force or compel or convince the person to leave, so they could then apply this first rent doctrine and create market rents. So this was the source of tension for rent stabilized tenants. It was reduced the supply of affordable rental units in the city, and was something overall that tenant advocates wanted to do away with. So in 2019, the state legislature got together and they passed a series of reforms, which most of you probably are somewhat familiar with, known as the HSTPA, or the Housing Stability and Tenant Protection Act. So that law was very comprehensive, and it eliminated many of the loopholes in rent stabilization that had existed for decades. So it was a great victory for tenants. However, the loophole for the Frankenstein apartments, or the combining or enlarging apartments, was not completely eliminated, because the landlord could still charge a first rent. So even though deregulation was no longer allowed, they could still charge a first rent. So we still, after 2019, we still saw a lot of cases where a rent stabilized tenant would leave, and the tenant of the adjacent units would be harassed, compelled, convinced, whatever, to move. And the landlord could combine the apartments, and they couldn't deregulate it, but they could charge market rent. So you could see, 2 units for $1,000 become vacant. The owner combines it and rents them for 4,500 or whatever. So that was what we were seeing. So finally, in 2023, the both the state legislature and the New York State Division of Housing and Community Renewal, or DHCR for short, passed changes in the law to eliminate this loophole for good, which is great. So the first thing that happened was that the state legislature last summer 2023, they passed a law to eliminate this loophole. The governor didn't sign it right away. She held on to it, or it was not maybe not formally presented to her right away for signature. So in the meantime, the DHCR started a process of changing or amending, is the technical term, the regulations, the rent stabilization code. And that was completed in November 2023. And then finally, in December 2023, the governor signed the Frankenstein bill into law. So it is now officially part of both the rent stabilization law and the rent stabilization code, which is great. And what that law does is it eliminates this loophole. It does not prohibit a landlord from combining apartments, but what it does is it says that if a landlord combines apartments, there's no first rent anymore. The rent would be the combined total of the rent stabilized rents of the two apartments. If it's just a partial combination, that is taking a 1-bedroom apartment and making it into a 2-bedroom by adding a room from a vacant adjacent apartment, then there's no first rent either. Then that the new rent for that apartment would be what the amount that the apartment was, and then plus a like pro rata increase based on the additional square footage for the apartment. There's also different rules about that go into great detail about if you combine a rent stabilized apartment with an apartment that's not rent stabilized, or partially, or the like. So those rules are all set out in great detail in the law. There's also a non-harassment section of the law, which says that the landlord's not allowed to raise the rent at all if it's found that the vacancies were achieved by harassment. And as far as improvements, let me just say this. A landlord's ability to raise the rent for improvements, for renovations, is now severely limited. It can't be more than $85. And that's for a 30-year period, and then it's eliminated. So there's no more like massive rent increases for improvements that used to exist up until 2019. So uh, the most is $85. So that would apply in this Frankenstein situation as well, where you have um, two apartments that are being combined. If the landlord wants to do some improvements, put in new cabinets, new shower, new tub, new stove, refrigerator, etc., they can do so, and they can increase the rent, but by no more than $85. So this is sort of what we're talking about now is sort of one of the finer points of rent stabilization, and it may not apply to a lot of people, but it applies to a number of people, a number of apartments, and it has been a tool that has been used by landlords for decades that they no longer have. And I would say that it took a lot of effort um, by the tenants' rights community to get this particular reform enacted, as can be seen by the fact that it took the governor 6 months to sign the bill, to be convinced or decide to sign the bill. Always, I think, in the area of tenant reforms in the state legislature and the governor's office, there's a multitude of issues being discussed all at once, different reforms. You have the real estate industry in there, very powerful lobby, a lot of effort that they make to try to keep uh, loopholes, many loopholes as they can in the rent stabilization law. So this uh, may seem like a very small loophole, but it was having a really bad effect on a lot of tenants. It was reducing the number of affordable units in the city, and it was incentivizing landlords to harass people to move out so that they could have two adjacent vacant units. Uh, and I would say in my practice, especially after the 2019 amendments, that people would come to me and they would say, their neighbor moved out and they were nervous that, that the landlord was pushing to get them out, because they knew about this Frankenstein option that the landlord had, and I saw a number of eviction cases against people in this situation escalated dramatically over that period of time, so that I'm talking about people who were longtime rent stabilized tenants in a building where an adjacent unit had just become vacant. That there were many increases in eviction proceedings against those tenants, and it was specifically because they were targeted to try to achieve this first rent, Frankenstein high rent, removing a unit from affordability, process that had gone on for many years before that. And after 2019, it was one of the few tools that landlords had left to remove rent stabilized units, or to not remove them completely, but to make them unaffordable. So landlords were really pushing this in the 4 years between 2019 and 2023. And now that has been eliminated. So that's, a major step for tenants' rights in New York City. It's not retroactive, obviously, but any um, any time that there's two vacant units next to each other now, these new rules would apply. So it should result in a decrease in frivolous eviction suits and tenant harassment. Um, so I could talk a little bit more about, there are a few remaining loopholes in the rent stabilization law. I could talk about them very briefly. One would be co-ops and condos, which that number of co-op and condo conversions in existing, old apartment buildings has gone down dramatically, but there are a number of rental units in those buildings that converted like between the 80s and now. There's tens of thousands of them at least that are still rentals, not co-op or condo owned or you occupied, that are not rent stabilized because of a loophole in the law. So that's one major loophole. Another loophole is when a unit leaves rent control, which at this point is a rapidly dwindling number of units, but say there's like maybe 10,000 of them left compared to 1 million under rent stabilization. So if a rent controlled unit becomes vacant, then the landlord can charge market rent to the next tenant. It may still be rent stabilized, maybe become rent stabilized, but could be market rate as to the next tenant. So anyway, it has been 20 minutes. I covered everything that I wanted to cover. I can go into more detail if anyone is interested. So I'll just turn it back to Jakari.
Yeah, thank you, Ron. So yeah, Ron is done for right now. So we're gonna just answer a few questions that we got so far. Question is, how does DHCR regulate the decrease in apartment sizes?
If there's a decrease in the apartment size, then it's based on the square footage reduction compared to the total square footage of the former apartment. So if it was 1,000 square feet and they took off 100 square feet, then the new legal rent would be 90% of the former legal rent, or it would be reduced by 10%.
Mhm. And that's after DHCR like finds out it was increased. That what happened?
Right. I mean, the owner is supposed to file um, with the DHCR to indicate the reduction and the new legal rent. There would be penalties to the owner if the owner failed to make those filings. So it's possible, and I have heard such things, that a tenant could be rented an apartment and find out that it's reduced from the former size. They could contact the DHCR for their registration history, and then contact an attorney for advice as to how to proceed with a rent overcharge case.
Okay, got it. The next question is, how can I sue my landlord if my apartment was illegally deregulated?
Okay. You can sue your landlord if your apartment was illegally deregulated by filing. You can retain an attorney to file a lawsuit in New York State Supreme Court alleging illegal deregulation and overcharge, or you can file a rent overcharge complaint with the DHCR alleging illegal deregulation. You will need to provide the basic factual allegations in support of your claim. If the landlord turns around and disputes that and says it was a lawful deregulation, the landlord will have the burden of coming forward with the, proper evidence of the legal deregulation. So a common scenario is that, maybe as many as 300,000 or more apartments were deregulated between 1993 and 2019. Many of them were deregulated illegally. It would be, if the tenant filed suit or filed a complaint with the DHCR, the landlord would have to produce the evidence to show that it was a lawful deregulation. Typically they would have to produce the lease of the last rent stabilized tenant, and then the records to prove that the rent was lawfully increased at the time to the level where deregulation would have been allowed. Like, for example, let's say an apartment became vacant in 2012 with a rent of $1,800. And then the next tenant moved in as a deregulated tenant with a rent of $3,000. So the landlord would have to prove, at the time, the threshold was $2,500. So the landlord would have to prove that the rent was lawfully increased from $1,800 to $2,500 at that time. They would have to produce the leases, and if they were claiming that they were entitled to pass on improvement or renovation costs, they would have to produce the proof of that, the invoices, the canceled check payment records, contracts with the contractor who did the work, the receipts for the appliances, etc. And then the tenant would have the right to dispute that.
Okay. The next question says, can my rent increase if my landlord asks me to move out for repairs?
The short answer is no. Your rent cannot, if you're a rent stabilized tenant and the landlord is asking you to move out for repairs, no, the landlord cannot increase the rent for that. I would say that anyone who's in that situation would be strongly advised to consult with an attorney to make sure their rights are protected, and make sure that there's a written agreement for the temporary relocation, not just a verbal agreement, and that the written agreement should spell out all the terms. As the person said, that the landlord asked, the landlord can, it's very rare that a landlord can require a tenant to move out for repairs. So it would generally be a decision the tenant would make, that it's in their best interest to agree to relocate. Certainly one of the key points would be that they have 100% assurance that they can return. And then, as the person said, with the increase in rent, again, the answer is no. There cannot be an increase in rent for that.
Okay. How will I know my apartment is Frankenstein?
Right. Good question. You may very well not know. It's very difficult to figure out sometimes. You can, if you suspect it, you can try talking with, friendly, helpful neighbors who may have been living in the building at the time to see what they recall. Another thing you could do is check with the New York City Department of Buildings to see if any permits were obtained at the time, alteration permits. It might be possible if you could gain access to the neighboring units, if on friendly enough terms with them, you could have a look around. if you could afford it, maybe you could hire an architect if you really strongly suspect that, to have them, look with you. I don't know. I think someone with expertise in apartment renovations might be able to tell by looking at the walls and the other surfaces of your apartment whether or not it appears like the flooring was extended, for example, or if the walls in one side are different material or appear to be newly installed compared to the rest of the walls of the apartment. If it looks like plumbing fixtures were moved, um, toilets, showers, sinks, whatever, that would be a possibility. So that's not an exhaustive list by any means. It's a good and intriguing question, but that's something to get someone started.
Okay, thank you, Ron. The next question is, how do I report illegal construction in my building?
You report illegal construction in your building by calling 311. And you ask to make a complaint file a complaint with the Department of Buildings. That's the primary way. You can also contact the Department of Buildings directly by email, or sometimes people reach out directly to the borough office by phone of the Department of Buildings that can reach the deputy commissioner's office that way. If it's something really serious, especially life-threatening situation, you might want to do that. It's possible the fire department would get involved if it was a fire safety issue. It's possible the Department of Environmental Protection would get involved if there's a noise issue as well. For example, construction going on after hours.
The next question is that one of the attendees want to know information about your firm.
So my firm is a private firm. We charge for all of our services. We offer initial consultations to tenants, co-op owners, condo owners, tenant associations, commercial tenants, as well as residential tenants. And we represent people in a variety of matters, including court matters, such as defense of eviction proceedings or HP actions for repairs, rent overcharge lawsuits, harassment cases, and a variety of cases where we represent tenants. And our website is hmgjlaw.com, and you can find out more about our firm there.
You have a phone number?
Yes, it's 212-349-3000.
So I'll just put the firm's phone number in the chat. So the next question is, so if your rent is stabilized, should your rent go up by 1 or 2% every year?
If your rent is stabilized, it goes up when your lease is renewed. And under rent stabilization, a rent stabilized tenant is offered the choice of a 1 or a 2-year renewal. And every cycle, every year, something called the New York City Rent Guidelines Board holds a series of public meetings and public hearings. And at the end of the process, they decide what the percentage rent increases will be for 1 and 2-year renewal leases for rent stabilized tenants for the coming year. So the increases right now are more than 1 or 2%. They have been as low as 0 in past years, but in recent years with the Adams administration, they have tended more to like three or 3.25, 3.5 for 1 year, and five and something for 2 years. So the members of the board are selected by the mayor. There are 2 tenant members, 2 owner members, and 5 public members. So the five public members have the balance of power on the board. It's a 9-member board. I served on the board as a tenant member from 2007 to 2010, which was a difficult time to be a tenant member because that was the Bloomberg administration. But that's how the process works. So there's never sometimes people ask, well, what will the rate increases be for next year? Well, the answer is no one knows, because it's decided by the board usually around the end of June for the leases that go into effect from October 1st through the following October 1st. So the increases that are in effect now, they will apply to leases that expire up through September 30th. And then as of October 1st, 2024, there will be a new cycle and a new amounts for 1 and 2 year leases. And we won't know what those amounts will be until the end of June. If people are curious and they want to find out more about it, they can go to the New York City Rent Guidelines Board website. There's a lot of information there. They're very transparent. I will say this for them. They publish all their studies. They do a number of studies every year. They publish them all. They're publicly available. They're free. And there's a lot of data in there. So you can read about it at the website. But no one can tell you what the increases will be from October 1st of this year on, because they're not set yet.
Got it. I think this is from an attendee that came in a little late. They're asking if you can explain Frankensteining, the term, one more time.
Sure. So Frankenstein, we know the book and the movie. It was about a mad scientist who, I guess, created a living being out of I don't know, machinery, or I don't really know the details. But in New York City landlord tenant law, Frankensteining is you take a vacant rent stabilized apartment and you make it into something else by either enlarging the outer dimensions, combining it with adjacent the next door vacant apartment to make one large apartment, or sometimes to reduce it, make it into 2 smaller apartments, or some other kind of combination of apartments. So the end result is that the outer dimensions of that apartment are changed from what the previous rent stabilized apartment was. And what the new law does is it eliminates a loophole that landlords had where they could set a first rent at whatever they wanted. And now that they're prohibited from setting a first rent, the landlords must follow a specific formula so that the units will still be not only rent stabilized, but they'll be still affordable.
And so the person who has their hand raised, could you ask your question in the Q&A? Thank you. The next question is in Spanish. So right now, if you do have the globe at the bottom of your screen, please make sure you're on your right listening language so you can hear the translation. And
Um, well, I think I would have to ask the person more questions, and I would suggest that they try to have a consultation with an attorney. So because I don't think I have quite enough information that I could give a good answer or correct answer to the question, but I would recommend that they maybe reach out to Palante about seeing if they can have a sit down meeting with an attorney, or some other organization that offers legal consultations to tenants. Because I think the main thing I would be interested in hearing about would be the circumstances under which the person left and then returned, and when this took place. Was this before or after the new law was passed? Um, and was there some period of time that elapsed, but how long a period of time elapsed between the time the person left and the time the person came back, or what happened with the apartment then? Was there someone else there, or what were the circumstances? So I think it's probably too much to get into in a public forum such as this, but I would encourage you to um, see if you can arrange to talk to an attorney on a one-on-one basis about that, to get a more precise answer to your question.
So that person, please contact Palante with that matter. The next question is from an anonymous attendee. It says, I've seen situations where landlords modify common ground and sometimes the construction is done externally. For example, a balcony is added to adjoining building. Wait, balcony is added to adjoining build through a window. How is the rent determined in such a case? And is that legal?
A balcony is added outside of a window?
You have the Q&A open?
No, but I
Yeah.
will. That's a good point. Oh, okay. I have it now.
720, the second one.
A balcony is added to adjoining build through a window. How is the rent determined in such a case? That's an interesting question, and I'm not sure I know the exact answer. Traditionally, the courts always said that a balcony is not a room, and that does not increase adding a balcony does not increase the outer dimensions of an apartment. So I do not, based on that past ruling, I do not think that the rent could be increased for based on additional floor space of the addition of a balcony, but there could probably be an $85 increase for improvements if it was $15,000. It seems like a lot to be provided with a balcony. That seems like a lot of work for a rent stabilized apartment in this day and age, but where the increases are limited to $85. I mean, balconies are, super desirable in New York. People love having them, and they're typically prepared to pay, a lot more rent for it. So I I don't know the circumstances of when this was done, for example, but if it was done prior to 2019, it could have been an improvement and the rent could have been raised substantially. Nowadays, I don't know what incentive there would be for an owner to legally, install a balcony to a, rent stabilized apartment, because as I understand the law, I don't think the rent could be increased by that much.
The next question is, what do we do if we find that it has been Frankenstein? That they're referring to the apartment?
I would I would contact the DHCR to request the registration history for your apartment, and then I would contact an attorney to check to see if you can find out if the um, registration filings match what your observations of the unit, that the rent had, if does it appear as if the rent has been adjusted by an appropriate amount or not.
Okay. Um, the next question is, in a two-story building with only 6 to 10 tenants, are we allowed to make a garden in our roof? I don't know if you can answer that one.
Um, I do not know offhand the rules and regulations with regard to a roof of a two-story building. So that has to be considered. And the other thing is whether the landlord, even if it was allowed, whether the landlord would permit it. It's not technically part of your apartment. It's a public space. So I do not know, because of a lack of knowledge of that specific. Well, part of the reason I can't answer is because I don't know what the rules are about having gardens on a two-story building. That's number one. And then the second thing is, would be, even if it was allowed, would the landlord, agree to it?
Mhm. Um, this is a follow-up to the question about what to do if you find out it's Frankenstein.
Right.
Would you be looking for in the rent registration history specifically?
What you would be looking for is the adjustment in the rent that took place after the Frankensteining, um, to see whether it appears that the adjustment of the rent is consistent with the rules. That is, if the apartment was increased by 10% in the floor space, then they could have raised the rent by 10%. If it looks like it was increased by a lot more than that, then you may have an overcharge claim.
The next question is, if if the apartment is Frankenstein, is there any rent regulations, or can they charge whatever they want for the unit?
Right. So that's precisely the point we've been discussing. So a good question. So the answer is, there are lots of regulations now. That's what the purpose of this discussion is, that these rules have just gone into effect just over the last few months. So any kind of combination of apartments that takes place, or chopping up of apartments that takes place as of now or for a few months ago into the future, they cannot charge whatever they want anymore. There's rules and regulations that cover it.
The next question says, I am involved in a tenant association and know of a tenant who moved in 2019, paying 2,050, but the last person who vacated paid $780 via DHCR, calculated over 60,000 since 2019 rent. Yes, there was an IAI, but when does the rent stabilized tenant stop paying such a large amount of rent?
So the law changed June 14th, 2019, very precise date. So if the person moved in before that date, the old law would apply. If they moved in after that date, the new law would apply, which would limit the IAIs to $85. But I have seen several instances of owners increasing the rent after June 14th, 2019, in violation of the law. So it's happening. I've even seen scams where they backdate a lease. Like, say someone moves in July of 2019 and they backdate the lease to June 1st to make it look like it was legal, because the change of the law took place June 14th, 2019. So that's a very specific bright line of a date on this improvement increase change in the law. So and landlords have challenged it in the courts and they've been unsuccessful. So that's a very bright line date. So if you first moved into an apartment or rent on or after June 14th, 2019, the current rules apply, and the rent increase would have been limited to $85, no matter how much they spent. If they spent, $50,000, it doesn't matter. They still could only raise the rent by $85. And I would just, some landlords have gone to court and they've said that's not fair. We paid the $50,000 for the renovations, before the law changed. And the courts have rejected those suits by landlords. So unless the courts change their mind, the June 14th, 2019 date is very precise and specific in the law, and it doesn't matter when the landlord signed the contract with the contractor or paid the money to the contractor or did the work. What matters is the date that the tenant moved in. And if it's after that date, then they're limited to the $85.
The next question, which I think is our last question, is how a defense of latches used in court.
I'm sorry?
How a defense of latches is used in court.
Oh, a defense of latches? Sorry, excuse me. Sorry about that. No, it has another. Yes, it's spelled in the legal term is not latches on a door. It's spelled differently too. It's LACHES. So in court, it refers to a delay by a party in making a claim against another party that they have. So the most common one in landlord-tenant law would be a landlord waits 3 years to sue a tenant for non-payment. They sue a tenant for non-payment. After 3 years, the tenant has to pay rent for 3 years. And they say to the court, if the tenant doesn't pay up the whole 3 years of rent, they should be evicted. The court would be likely to rule against the landlord in that case on the eviction part and say only as to the most recent arrears would the tenant have to pay to avoid eviction. So there could still be a money judgment against the tenant for the 3 years, but not a possessory judgment, not an eviction judgment, because the landlord waited too long. The landlord is guilty of latches, is the term that you hear in the courts. And it's a general term that that's applied to different types of lawsuits, and it's applied on a case-by-case basis. So, not every tenant that goes for 3 years without paying rent is going to be successful in a laches claim, but many of them are. The courts will look at all of the circumstances in order to decide if the laches defense is available.
Okay. So I think that was the last question for tonight. So I want to thank Ron, of course, for being here, answering all of our questions and all of our attendees' questions, educating us on signing and how it affects tenants. We do have a document that I'm going to share after to the attendees. Ron, can you explain again? You said it's like the law, the actual Frankenstein.
Yes, I provided a copy, the full text of the rent stabilization law and the rent stabilization code, the provisions about Frankenstein apartments. And they're very detailed and specific, and probably more in the weeds, as we say, than the majority of people need. But, I thought I would provide that to you, to anyone who might care to read all about it and know all the details.
Send that out probably tomorrow or Monday to everyone. I hope this webinar was informative for everyone that joined. Hold on. Right, so I hope this webinar was informative for everyone that joined in tonight. Yes, I will email everybody the details of the law that Ron just discussed. And I hope everyone has a wonderful evening. I'm gonna put a short poll up so we can know how this webinar went for everyone that joined in. And once again, thank you to Ron, thank you to our attendees for being here and asking questions. And thank you to our interpreter, Daniel, who interpreted this whole webinar for us. And Ron, if you have any last words you could say, or you want to say good night.
No, just that I enjoy doing this, and thank you for all the great questions.